A mother is supposed to be the last line, the one who stays when everyone else has gone, the one who absorbs what she cannot stop and keeps standing anyway. Every child arrives in the world already trusting that the person holding them will not be the source of the harm. That trust is not earned. It is built into the biology. It is the oldest contract there is, the one written before language, before memory, before the child has the vocabulary to understand what safety means, or why they feel it when certain arms close around them. The 10 cases in this script are about what happens when that contract is broken from the inside. Each one involves a mother. Each one involves a child who did not survive. And in each one, after the child was gone, a choice was made. To run, to hide, to lie, to build a story large enough to stand between what happened and the people asking questions. The children in these cases deserved more than they were given. Case 1. Andrea Yates. The morning of June 20th, 2001 began the way most mornings did in the Yates household on Beachcomber Lane in Clear Lake City, a quiet subdivision on the southern edge of Houston. Russell Yates, known to everyone as Rusty, left for his job at NASA before 8 o'clock. The children were still waking up. The oldest, Noah, was 7, John was 5, Paul was 3, Luke was 2. Mary, the only girl, was 6 months old and had been born the previous November, during a period when her mother's doctors had told the family, in plain terms, that another pregnancy was not advisable. Andrea Yates stood in the kitchen as her husband's car left the driveway. Her mother-in-law, Dora Yates, was scheduled to arrive within the hour to help with the children. In the space of that hour, everything ended. Andrea Kennedy had grown up the youngest of 5 children in a Houston family that her relatives described as stable and close. She was a strong student, graduating as valedictorian of her high school class, and went on to earn a nursing degree that led to a well-regarded position at the University of Texas MD Anderson Cancer Center, where colleagues remembered her as composed and thorough. She met Rusty Yates in the summer of 1989 at an apartment complex in Houston. They were married in April 1993. Within a year, Noah arrived. The couple had agreed early on that they wanted a large family, and Rusty's religious convictions reinforced that position. He had been introduced to the teachings of an itinerant street preacher named Michael Woronetsky, whose writings and cassette tapes circulated among a small but devoted following and carried a central message: that mothers who failed to raise righteous children would be responsible for those children's damnation. Andrea absorbed those teachings. She listened to the tapes, she read the newsletters, she homeschooled Noah and John at the kitchen table each morning and kept a home that was, by most accounts from neighbours and relatives, orderly and attentive. But the pregnancies were taking something from her. After Luke's birth in 1999, Rusty found her in the bathroom at her mother's house one evening, standing in front of the mirror with a knife held to her throat, catatonic. She was hospitalised. She was diagnosed with postpartum depression. She improved. She was released. The couple decided to have a 5th child. Mary was born in November 2000. 4 months after Mary arrived, Andrea's father died suddenly, and whatever equilibrium she had maintained gave way entirely. She stopped eating. She stopped speaking to family members. She scratched at her own scalp until the skin broke. She was hospitalised twice more in the months before June 2001, and her psychiatrist, Dr. Mohammed Saeed, had given standing instructions to Rusty that she was not to be left alone with the children. On the morning of June 20th, Rusty left anyway. He would later say he believed she was stable enough. He would later say a lot of things. What happened in the hour between his departure and Dora Yates's arrival was reconstructed through Andrea's own account to investigators, which she gave willingly and in detail. She filled the bathtub. She brought Paul in first, then Luke, then John. She laid their bodies on the master bed afterward and covered them with a sheet. Then she brought Mary. She left Mary in the water. Noah came down the hallway and saw his sister floating and asked his mother what was wrong. Then he ran. Andrea told investigators she caught him at the doorway to the hall and brought him back to the bathroom, and that she held him face down in 9 inches of water while his infant sister's body drifted beside him. When it was over, she pulled Mary out and placed her in John's arms on the bed. Then she called 911. She told the dispatcher she needed a police officer. When the dispatcher asked why, she said she needed an officer to come. She called Rusty at work and told him to come home. When the officer arrived, Andrea Yates met him at the front door. Her hair and clothing were wet. She said calmly, "I killed my kids." The Houston Police Department and the Harris County Medical Examiner's Office handled the investigation that followed. The Harris County District Attorney's Office, led at the time by Chuck Rosenthal, filed capital murder charges and sought the death penalty. The trial opened in February 2002. Andrea's defense attorneys, George Parnham and Wendell Odom, argued that she had been legally insane at the time of the drownings, that her psychosis was severe and documented and real, and that she had believed, in the grip of that psychosis, that her children were already corrupted by Satan, and that taking their lives before they could grow older was an act of mercy, saving them from a worse fate in the afterlife. Prosecutors argued that the sequential, methodical nature of what she had done, 5 children, one after another, bodies arranged on the bed, infant placed in her brother's arms, demonstrated planning and intent, and the capacity to know right from wrong. Rusty Yates sat in court throughout the proceedings. He did not blame his wife publicly. He pointed toward her doctors, toward the insurance constraints that had forced her early discharge from psychiatric care just weeks before the drownings, toward the antidepressant medication she had been prescribed at twice the recommended dose. He maintained, then and in the years that followed, that the system had failed her. Andrea's own family, including her brother Brian Kennedy, told a different story. Kennedy said publicly that Rusty had once described depressed people as needing a swift kick to get themselves moving, and that he had left his wife alone with 5 children in direct contradiction of her doctor's explicit instructions. The jury heard the competing accounts. In March 2002, after deliberating for less than 4 hours, they convicted Andrea Yates of capital murder. They declined to impose the death penalty. She was sentenced to life in prison with the possibility of parole after 40 years. The conviction did not stand. In January 2005, a Texas Court of Appeals overturned the verdict because a prosecution expert witness, forensic psychiatrist Dr. Park Dietz, had given false testimony during the trial. Dietz had claimed, incorrectly, that an episode of the television program Law and Order, depicting a woman who drowned her children and was acquitted by reason of insanity, had aired shortly before the murders, implying that Yates had constructed her insanity defense from a television plot. The episode did not exist. Dietz retracted the claim. The appellate court ruled the false testimony had influenced the jury and ordered a new trial. In February 2006, the retrial began. This time, after 3 days of deliberation, the jury found Andrea Yates not guilty by reason of insanity. She was committed to the North Texas State Hospital in Vernon, a high-security psychiatric facility. Within months, she was transferred to the Kerrville State Hospital, a lower-security institution in the Texas Hill Country, where she has remained. Rusty Yates filed for divorce in 2004. He remarried in 2006. He maintains a memorial website for his 5 children, where brief biographies describe each of them in the language of a father who is still trying to tell people who his children were before the morning they were taken. Noah, who loved drawing rainbows and butterflies and building things from whatever he could find, and who asked his mother what was wrong with Mary before he understood what was happening. John, born a week late and described by Rusty as arriving a little grumpy, who loved trucks and swimming. Paul, whom his parents called Perfect Paul, who danced to whatever was on the radio and was devoted to the NASA channel and the idea of rockets. Luke, who helped his mother in the garden and played alongside his brothers on the living room floor. Mary, 6 months old, who had been born into a household that was already fracturing in ways that no one outside it fully understood. They are buried together at the Forest Park Lawndale Cemetery in Houston. Andrea Yates continues to receive psychiatric treatment at Kerrville. She has, by multiple accounts, expressed remorse consistently throughout her years of confinement. Her defense attorney George Parnham and his wife created the Yates Children Memorial Fund in 2002, with Andrea's knowledge and encouragement, to raise awareness about postpartum depression and psychosis. She follows the fund's work closely. The question that her case posed to courts, to psychiatrists, and to the public, whether a person in the grip of documented severe, medically verified psychosis can be held criminally responsible for acts committed inside that psychosis, was never cleanly resolved. What the second jury decided was that she could not. What the families of the 5 children are left with is something that no verdict addresses. The Beachcomber Lane house was sold. The neighbourhood continued as neighbourhoods do. The names Noah, John, Paul, Luke and Mary are on a headstone in a Houston cemetery and on a website that their father still maintains, and in the court record of a case that reshaped how postpartum psychiatric illness was discussed in American medicine and law. Every 2 years, Andrea Yates goes before a review panel at Kerrville. Every 2 years, the panel determines that she remains committed to her treatment and poses no danger to the public. She has never been released. She has never stopped being the woman who filled a bathtub on a Wednesday morning in Clear Lake City, while her mother-in-law was 20 minutes away. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case moves from Texas to rural Oregon, and to a mother whose calm, flat effect in a hospital emergency room on the night of May 19, 1983, told investigators almost everything they needed to know before they had even begun asking the right questions. The detective who took her statement that night would later say that in 30 years of law enforcement, he had never interviewed anyone who seemed less like a person who had just watched her children get shot. Case 2. Diane Downs. The emergency room bay at Mackenzie Willamette Hospital in Springfield, Oregon, was quiet on the night of May 19, 1983, until it wasn't. A car pulled in slowly. Witnesses would later note that it was moving at a pace that did not suggest urgency, which was one of the first things the hospital staff found strange. And the woman behind the wheel stepped out and told the orderlies that her children had been shot. The children were in the back seat. Cheryl was 7, Christy was 8, Danny was 3. All 3 had been struck at close range by a small caliber firearm, and by the time the hospital staff reached them, Cheryl's wound to the chest had already done what it was going to do. She was pronounced gone at the scene. Christy and Danny were rushed inside in critical condition, Christy without a detectable pulse and not breathing on her own, Danny with a wound to his spine that would leave him without the use of his legs for the rest of his life. The woman who had brought them in had a gunshot wound to her left forearm. It was not life-threatening, she was composed. She was, as the detective who interviewed her that night would later describe it, emotionally flat. Her name was Diane Downs, and she had a story ready before anyone had thought to ask her for one. Diane Fredrickson was born in Phoenix, Arizona, in August 1955. The second of several children in a household her relatives described as strict and cold. She described her upbringing in similarly direct terms. She married a man named Steve Downs in 1973, she said at trial, not because she loved him, but because marrying him was a way out of her parents' house. Christy arrived in 1974, Cheryl in 1976. A third pregnancy ended in an abortion she later said she regretted. Danny was born in 1979, the product of an affair, and Steve Downs walked out in 1980 when the circumstances of Danny's parentage became clear. Diane found work as a letter carrier for the United States Postal Service, first in Arizona and later in Cottage Grove, Oregon, where she had moved to be closer to her parents. She was, by most accounts from people who observed her during those years, capable and driven. She held her route, kept her schedule, managed 3 children largely on her own. People who knew her in those years described a woman who was simultaneously magnetic and self-contained, someone who drew others into her orbit through the force of her personality, and then revealed very little of what moved underneath. She had short-term relationships with multiple men after the divorce. Relationships that began quickly and ended before they required depth. Co-workers in Arizona and later in Oregon described her as someone who talked about her children often in public settings, but who, by the account of her former husband Steve, and others who spent time around the family at home, demonstrated little warmth toward them in private. Steve told investigators and later the court that she treated her children like, in his word, crap, and that she lacked the instincts that the children needed from her. He recounted catching Cheryl jumping on her bed one afternoon and telling her to sit down and think about what she had done. Cheryl sat quietly, then looked up and asked if there was a gun in the house. When he said no and asked why, Cheryl said she wanted to use one on herself because her mother told her she was bad. Cheryl was young enough at the time that the statement registered not as drama, but as the earnest articulation of a child trying to make sense of the messages being sent her way inside her own home. By the spring of 1983, Diane Downs had developed a consuming fixation on a married man named Robert Knickerbocker, a former co-worker she had known in Arizona. He was not interested. He had reconciled with his wife and told investigators he was relieved when Diane left Arizona for Oregon, hoping the distance would end what he described as her stalking. She wrote to him constantly, letters that went unopened and returned. When investigators later found her private diaries, they read like documents that answered every question the case had raised. Knickerbocker had told her plainly that he would not be a father to another woman's children. Lane County Detective Doug Welch, who took her statement on the night of May 19th and would spend the next year building the case against her, told reporters and later testified that the working theory became clear early. The children were in the way. As long as they existed, the relationship she wanted could not exist either. The diaries described her obsession in language that made the motive visible without requiring interpretation. Prosecutors told the jury that Diane Downs had looked at her 3 children and seen 3 obstacles. What she told the hospital staff and police that night was this. She had taken the children out to visit a friend who kept horses in the Marcola area, and on the drive home, in the dark, she had taken a detour onto Old Mohawk Road to do some sightseeing. Her children were asleep in the back seat. A man stepped out from the roadside brush and flagged her down. He wanted her car. She refused. He pushed her aside and opened fire on the children through the car window. She pretended to throw her keys into the nearby brush to distract him, shoved him away, got back behind the wheel, and drove her children to the hospital. During the struggle, he had shot her in the left forearm. She described him as having shaggy brown hair and a stubble beard. He wore a leather jacket. She had never seen him before. Welch noted the inconsistencies before he had finished writing them down. Sightseeing in pitch darkness on a back road with 3 sleeping children. Stopping for a stranger at night. A carjacker who wanted the vehicle badly enough to shoot 3 children, but who could be distracted by thrown keys. The superficial nature of her own wound compared to the severity of what had happened to the children. And underneath all of it, the tone of the interview itself. Welch would say later that she was the calmest person he had ever sat across from in a room where her 7-year-old had just died. The forensic evidence collected in the days that followed made the story harder to sustain with each item logged. There was no blood spatter on the driver's side of the car interior, no gunpowder residue on the exterior driver's door or the inside door panel. The car had been driven to the hospital slowly, not at speed. Witnesses on the road that night reported no signs of a struggle, no fleeing figure, no second vehicle. When investigators examined unfired cartridge casings found at Diane's home, the extractor markings matched the casings recovered from the scene. She had told police she did not own a firearm of the relevant caliber. 2 former partners told investigators they had personally seen her with one. She was not arrested immediately. The investigation took 9 months, during which Diane Downs gave interviews to newspapers and television stations across Oregon and beyond, calm and consistent, maintaining her innocence, describing her grief. Those media appearances became, in time, one of the most discussed elements of the case in the years that followed, not because of what she said in them, but because of what she did not say, and what her face and her manner communicated to every person who watched them. She smiled at moments that had no smile in them. She described Cheryl's death in language that was flat and slightly performative, as though she were playing the role of a grieving mother from the outside, rather than inhabiting it. Reporters who covered the case and who watched those early interviews have described, across decades of retrospective coverage, the experience of sitting across from her or watching the footage and feeling a specific wrongness that they did not have adequate language for in the moment, but that became legible once the charges arrived. She visited Christy and Danny at the hospital and, according to prosecutors, made attempts during that period to arrange for Danny's adoption, as though the surviving children were a problem to be managed. Christy, meanwhile, was slowly fighting her way back from the stroke her injuries had caused. Her speech had been severely impaired. Physical therapists worked with her for months. Investigators waited. In February 1984, Lane County authorities took Diane Downs into custody. The charge was murder for Cheryl, attempted murder for Christy and Danny, and 2 counts of first-degree assault. The trial began in May 1984 and carried with it a detail that became one of the most discussed elements of the case. Diane Downs was visibly pregnant in the courtroom. She had identified a man on her postal route and pursued a relationship with him before the trial began. When reporters asked about the pregnancy, she gave an answer that was entered into the record of the coverage surrounding the case and has remained there ever since. She said she had gotten pregnant because she missed her children. She said children were easy to conceive and that they gave her love, stability, and a reason to be happy, and that what had been taken from her had been replaced. Her attorney argued the pregnancy was evidence of her love of motherhood. The prosecution argued it was calculation. Reporter Ann Yeager, who covered the trial, later recalled worrying in real time about whether the pregnancy would create sympathy in the jury, saying that Diane had clearly calculated that a pregnant woman could not be a child killer in the jury's imagination. The state's evidence came in over weeks. The forensics, the ballistics, the diary entries, the testimony of Knickerbocker, who told the jury about her obsession with him, about the letters, about his statement that he would not be a father to her children. And then, on a day that those present in the courtroom described later as one of the most quietly devastating moments they had witnessed in a legal proceeding, prosecutor Fred Hughey called Christy Downs to the stand. She was 9 years old. She had spent the better part of a year learning to speak again after the stroke her injuries had caused. She sat in the witness chair and looked at the room. Hughey asked her if she remembered who had shot her on the night of May 19, 1983. She answered without hesitation. "My mum," she said. 2 words. 9 years old, still rebuilding the ability to form sentences, and she gave those 2 words without equivocation to a courtroom full of adults who had spent months arguing about what had happened on Old Mohawk Road. The jury convicted Diane Downs on all counts in June 1984. She was sentenced to life in prison plus 50 years. The court took a recess before sentencing so she could give birth to the daughter she had conceived during the pre-trial period. The infant, whom Diane named Amy Elizabeth, was removed by the state and placed with adoptive parents in Bend, Oregon, where she grew up as Becky Babcock, unaware of her origins until her adoptive mother began providing small pieces of information in response to persistent questions. Christy and Danny were adopted by Fred Hughey, the prosecutor who had put their mother away, and his wife. Both grew up in Oregon. Christy attended college, married, built a family of her own. She named one of her daughters Cheryl. 3 years into her sentence, Diane Downs scaled an 18-foot razor wire fence at the Oregon Women's Correctional Center in Salem and walked away. She remained at large for 10 days while a manhunt covered 14 states. She was found at the home of another inmate's husband a few blocks from the prison. The 10 days of freedom added 5 years to her sentence. Investigators at the time believed she had been trying to make her way to Springfield, to Christy and Danny. After her recapture, prosecutors lobbied successfully to have her transferred out of Oregon entirely, arguing that the proximity of the Salem facility to the children was too great a risk. She was moved to New Jersey and later to California, where she is currently held at the Central California Women's Facility in Chowchilla. She has been denied parole at every hearing she has faced. The first denial came in 2008, after a hearing during which she participated via video link from California, answering questions for over 2 hours before the board deliberated for 30 minutes and turned her down. The second denial came in December 2010, at which point a new Oregon law allowed the board to extend the gap between her hearings to 10 years. A third denial followed in 2020. In October 2025, she appeared before the Oregon Parole Board again, still maintaining her innocence, still rotating through the versions of events she has offered across 40 years. She told the board she did not shoot her children. The board denied parole for the fourth time in December 2025. The written denial stated that Downs has a mental or emotional disturbance, deficiency, condition, or disorder predisposing her to the commission of any crime to a degree rendering her a danger to the health or safety of others, and that the condition which made her dangerous is not in remission, and she does continue to remain a danger. Lane County District Attorney Alex Gardner had written in an earlier letter to the board that she continues to fail to demonstrate any honest insight into her criminal behaviour, and that she alternately refers to her assailants as a bushy-haired stranger, two men wearing ski masks, or drug dealers and corrupt law enforcement officials. The story changes, the conviction does not. Psychiatrists who have evaluated her across the decades have applied terms including narcissistic, histrionic, antisocial, and deviant sociopath. She is 70 years old. Cheryl Lynn Downs, had she lived, would be 49. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. Next, the case moves to Largo, Florida, where a 2-year-old boy nicknamed Mr. Chuckles by the family who had raised him for most of his short life was returned to his birth mother 3 months before she carried his body into a wooded area and told police a man named Antoine had taken him. Case 3. Sharice Stinson. Saturday, September 1st, 2018 was still warm in Largo, Florida. The kind of Gulf Coast evening that holds its humidity long after the sun drops behind the tree line and the sky goes the colour of a bruise. Sharice Stinson called the Largo Police Department that night and told the dispatcher she had been attacked. She said she had been walking in the area of Largo Central Park with her 2-year-old son Jordan when a man pulled up alongside them in a white Toyota Camry and offered them a ride. She accepted. She said the man had struck her in the face once they were inside the vehicle, hard enough to knock her unconscious. When she came around, she was alone in a wooded area nearby. Her son was gone. She described the man as approximately 25 years old, with dreadlocks and gold teeth. She said he had told her his name was Antoine. She said the car had a woman driver. She said she did not know where they had taken Jordan or where they had gone. Within hours, the Florida Department of Law Enforcement had issued a statewide Amber Alert. Jordan Beliveau Jr. was 2 years old and 28 pounds and had a gap-toothed smile that the people who had spent most of his short life raising him described as the first thing anyone noticed when they looked at him. His face went out across the state that night on every screen that carried the alert. The Largo Police Department released an artist's sketch of the man Stinson had described. Volunteers joined the official search and spread out through the parks and streets and drainage corridors of Pinellas County. Family members climbed through underbrush and checked culverts and called his name into areas where sound flattened out against the trees. Community members shared the Amber Alert thousands of times across social media platforms. For 60 hours, Jordan Beliveau was missing, and the apparatus of a statewide search ran on the fuel of a story about a man named Antoine who had punched a mother unconscious and taken her child. On the 4th day, investigators found Jordan's body. He was in a wooded area behind a baseball field near the Largo Sports Complex, lying in 5 to 6 inches of standing water, partially covered with brush that had been placed over him. He was wearing the same clothes he had been seen in last. The Florida Department of Law Enforcement cancelled the Amber Alert in a brief statement that said, simply, that the child had been found deceased. Sharice Stinson was taken in for further questioning the same day. By the following morning, the story of Antoine and the white Toyota Camry was gone. Jordan Beliveau Jr. had entered the world in late 2015 in Pinellas County, under circumstances that the Florida Department of Children and Families flagged almost from the beginning. His father, Jordan Beliveau Sr., had documented associations with gang activity, and allegations surrounding the family's home environment included firearms, drug use, and domestic violence between the two parents. When Jordan was approximately 5 months old, DCF removed him from his biological mother's home and placed him with a licensed foster family in the Largo area. The family's name was Warren. Sam and Juliet Warren were the kind of people who took infants through the night feeding months and the teething months and the first steps months, who learned a child's rhythms before the child had a name for what hunger felt like, or what it meant to be held by someone who stayed. Jordan arrived at their home barely able to sit upright on his own. He learned to roll over in their living room. He learned to crawl with Sam's mother guiding him across the floor on her hands and knees beside him. He learned to walk and to talk inside that house, surrounded by people who showed up every morning. As he moved from infant to toddler, Jordan developed a personality that was, by every account from everyone who knew him, impossible to be around without feeling lighter. He was easy. He was warm. He had what Sam Warren later described to reporters as a twinkle in his eye that was present even in still photographs. Something in his expression that suggested he found the world more interesting than alarming. He laughed with his whole body. The family gave him a nickname that captured it precisely: Mr. Chuckles. The Warrens wanted to adopt him. They told the caseworkers assigned to Jordan's file that they wanted to make him their son permanently. The court moved in a different direction. What the court record shows about the 2 years between Jordan's removal from Stinson's care and his return to it is a document of missed signals, incomplete communication, and decisions made on the basis of compliance to paperwork, rather than genuine behavioural change. A DCF special review completed in January 2019 and released publicly on January 16th of that year laid out the failures in methodical detail. The review found that the decision to reunify Jordan with Stinson had been driven primarily by the parents' perceived compliance to case plan tasks, rather than by any documented evidence of changes in behaviour or lifestyle. Case decisions had been made without adequately addressing the overall family environment in which Jordan and Stinson were living. The case plan had never been modified, despite multiple documented incidents of domestic violence between Stinson and Jordan Sr. Stinson had given false information to the court on multiple occasions, including during a June 2017 abuse investigation and regarding her compliance with counselling requirements. She had missed 3 of her 5 scheduled visits and 7 of 11 visits with a clinician, and those absences had never been formally raised to a judge before reunification was approved. The incidents in Jordan's file that preceded the reunification were not minor administrative notations. A DCF report from early in the case described the home where Jordan was living with his grandmother as filthy, disgusting, and without food, despite the family receiving food stamps. At a Father's Day visit in June 2017, while Jordan was still in foster care under unsupervised visitation terms, his father got into an altercation at a Burger King. Stinson was there, carrying Jordan in her arms. A woman involved in the fight attempted to strike Stinson and instead punched the 10-month-old child in the lip. That incident was reported to the Child Abuse Hotline, along with allegations that Jordan Sr. was selling cocaine and marijuana from the home and that both parents were using drugs. Both parents refused to be tested. The investigation concluded with findings of inadequate supervision and failure to protect, and yet in the next court hearing on the family case, the presiding magistrate was never informed that this had been a gang-related incident, that Stinson had been present, or that Jordan had been struck. There was no mention of the need to screen the parents for drug use. According to Florida statute, DCF had been required to file a petition for termination of parental rights within 60 days of November 2017, the point at which Jordan had been in foster care for 12 consecutive months. That petition was never filed. On July 14, 2018, Largo police responded to Stinson's home following a 911 hang-up call. When officers arrived, they observed visible injuries to Stinson's face. She told them Jordan Sr. had punched her. When police located Jordan Sr. at his mother's home, he denied the assault, became combative, and made threatening statements toward both police and Stinson. He was taken into custody on July 15th. The incident was not reported to Child Protective Services until August 3rd, nearly 3 weeks later. An abuse investigation opened August 4th. During an initial visit to Stinson's home that afternoon, she refused to answer the door for over an hour while officers and investigators waited outside. A new child abuse report had also been received that August, alleging increased volatility between the parents. On August 8th, a case manager made an unannounced visit, but Jordan was not present, arriving later with his father and paternal grandmother. The case manager updated the safety plan, but did not escalate the accumulating concerns. On August 17th, an amended case plan was finally filed with the courts. It had not yet been heard by any judge when Jordan died. On August 24th, Stinson refused to allow the guardian ad litem into her house. The case manager was not contacted by the abuse investigator for the first time until August 29th, more than 3 weeks after that investigation had opened. On August 31st, the case manager made a home visit in the evening, spoke to both parents about the need to participate in services, and asked to see Jordan, who was sleeping. Stinson brought the child out of his bedroom. The case manager observed him, found no visible concerns, and left. Jordan was alive. Later that same evening, Stinson sent a text message to the guardian ad litem, apologising for her lack of participation and promising to do better. Less than 24 hours later, she called the police and reported her son kidnapped. In May 2018, the Florida Child Welfare System had ordered Jordan's reunification with Sharice Stinson over the written objection of the guardian ad litem assigned to represent Jordan's interests. He was returned to her custody 3 months before his death. The decision was made, the DCF review later confirmed, on the basis of a case plan compliance record that Stinson had partially fabricated and a family environment that no one had fully assessed. What Stinson told investigators after her fabricated story came apart was recorded in the arrest affidavit filed by the Largo Police Department. She said that on the night of September 1st, she had struck Jordan in the face with the back of her hand during a moment of frustration. His head struck the interior wall of the apartment. He began having seizures shortly after. She watched his condition decline through the night without seeking medical attention. She did not call 911. She did not take him to an emergency room. She did not contact anyone who could have intervened while there was still time to intervene. At some point during those hours, or possibly after he had already died, Stinson carried Jordan's body out of the apartment, through the neighborhood, and into the wooded area behind the Largo Sports Complex baseball field. She left him there in the standing water. She covered him partially with brush. Then she went back and called the police with the story about Antoine. The medical examiner's review confirmed that Jordan had died of blunt force trauma. His injuries were extensive, beyond what a single blow would typically produce, and indicated a pattern of physical harm accumulated before the final night. He had a healing cut on his chin. He had deep lacerations. He had a broken leg. He had a skull fracture, a brain hemorrhage, and bleeding beneath his scalp. The affidavit noted directly that it was unclear whether Jordan was still alive when his mother placed him in the standing water. Whether he was already gone, or whether he was placed there while something in him was still holding on, was a question the evidence could not definitively answer. He was 2 years old. He had been back in his biological mother's home for 12 weeks. The DCF secretary, Chad Popple, released a statement after the January 2019 review was made public. He said that despite multiple opportunities, no one had changed Jordan's circumstances. He said reviewing the events that led to Jordan's death was incredibly saddening. Largo Police Lieutenant Randall Cheney addressed reporters after Stinson's story unravelled. He stated plainly that the injuries Stinson had reported on herself were self-inflicted, and that during the time she claimed to have been unconscious in Largo Central Park, she had in fact been at another location, which was where investigators subsequently found Jordan. The man named Antoine did not exist. The white Toyota Camry did not exist. The Largo Police Department had used real resources, real personnel, and real investigative hours, chasing a story Stinson had constructed to point away from herself and toward a fictional stranger who fit a specific racial description. Sharice Stinson was initially charged with first-degree murder and aggravated child abuse. She entered a guilty plea in October 2020, more than 2 years after Jordan's body was found, with the murder charge reduced to second degree under a plea agreement. She also pleaded guilty to making a false report to law enforcement. The agreement required her to pay the Largo Police Department $27,843 to cover the costs of the investigation her fabricated story had generated. She was sentenced to 50 years in prison. At the sentencing hearing, she addressed the court and said she had been angry and bitter for a long time, and that jail had brought her a kind of mental freedom she had not known before. She said she loved her son. She said she had been lost. Jordan's death prompted Florida State Representative Chris Latvala of Clearwater to draft legislation requiring additional training for child welfare caseworkers to recognize signs of head trauma in children and improving communication pathways between law enforcement and the child welfare system. Governor Ron DeSantis signed what became known as Jordan's Law in the summer of 2020. Sam Warren gave a statement after Jordan's death that was precise in its grief and precise in its accounting of where the failure had occurred. He said Jordan had been failed by many people who should have protected him. He said promises made to the foster family about how Jordan would be protected after his return were broken. He said the family hoped Jordan's loss would lead to a fundamental re-examination of how the foster care and reunification system operated in Florida, because Jordan deserved that, and because the other children in the system needed it. Jordan Beliveau Jr. was 2 years old. He had spent the majority of his life with a family that wanted to keep him and named him Mr. Chuckles and watched him learn to walk across their floor. The same foster family who had raised Jordan later took in his younger sibling when Stinson gave birth while awaiting trial. 2 children from the same mother. One of them did not survive the reunion. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case moves to rural Iowa, where a mother drove her 2 young sons to a remote pond on an October afternoon in 2008 and left a handwritten note behind explaining what she planned to do, a note she later admitted writing herself to support the fictional story she intended to tell whoever found the scene. Case 4. Michelle Kehoe. Gene Kehoe left the house on the morning of Sunday, October 26, 2008, believing his wife was taking their 2 sons to visit her mother at a nursing home in Sumner, a small town about an hour northeast of their home in Coralville, Iowa. Michelle had told him that was the plan. She had the boys dressed and ready when he said goodbye. Sean was 7 years old. Seth had just turned 2. The drive to Sumner took about an hour on state roads through corn country, and Gene went about the rest of his Sunday without concern. Several hours passed. Evening came. The family did not return. By the time a woman named Deborah Hinn opened her front door the following morning at approximately 7:30 and found an injured person collapsed against the frame of her house on a county road outside Littleton, Seth Kehoe had been dead since the previous afternoon. The person on Deborah Hinn's doorstep was Michelle. She had a wound to her throat that had bled through her clothing. She was difficult to understand when she tried to speak, so Hinn handed her a piece of paper and a pen. Michelle wrote 4 words: "A man killed my boys." Coralville sits in Johnson County in eastern Iowa, a suburb pressed up against Iowa City, home to the university and its hospital, and the particular atmosphere of a college town that spills into the surrounding neighborhoods. The Kehoe household on its surface looked like many others in the area: a working father, a mother managing the children at home, 2 boys who had grown up inside the routines of a family that functioned well enough from the outside. Sean was a first grader. Seth was still in the full toddler years, the age when children are in motion constantly, when they require the kind of attention that does not pause. Gene worked. Michelle managed the house and the boys and the daily weight of a mental health history that had never fully lifted since the early years of their marriage. Her first documented suicide attempt had occurred in 1996. She had been treated across the years for depression and anxiety, hospitalized more than once, cycled through medications and therapy with the kind of incomplete resolution that characterizes severe and treatment-resistant illness. The people who knew the family from the outside saw a mother who was present, who took the children to their appointments and to the library, who managed the household without obvious signs of crisis. Gene would say at sentencing that she had been an excellent mother. He believed it when he said it. 10 months before the pond, in December 2007, the family's car had gone off a road in Iowa City and plunged into the Iowa River on a cold afternoon. 4 bystanders saw the car leave the road and dived into the freezing water to help. They pulled Michelle and the boys out through the windows. Iowa Governor Chet Culver later honored all 4 men at a ceremony recognizing their actions. The rescue made local news. Corey Rath, one of the 4 men, had stayed in contact with the family afterward. When he learned of Michelle's arrest nearly a year later, he told a Cedar Rapids television station that his heart had sunk. He said he had been grateful that Sean survived, but troubled by what the boy would face in the years ahead. He said dying at 7 would have been very tragic, and that the difficulties ahead for the surviving child were troubling to think about. Prosecutors at trial would argue that Michelle had told a defense psychiatric expert during trial preparation that the Iowa River incident had not been an accident. She had driven the car into the water deliberately, with her sons inside. The 4 men who dived into the freezing river to save them were never officially told what the prosecution alleged about their act of rescue. In the weeks before October 26th, Michelle Kehoe had been building toward what she had decided was going to happen. The planning was documented by prosecutors through receipts, witness accounts, and her own subsequent admissions. She purchased a Winchester hunting knife with a camouflage handle in September, approximately a month before the attack. She purchased duct tape. She identified the Hook and Liner Pond outside Littleton, in rural Buchanan County, as the location. The pond sits at the end of a county road in a part of Iowa where the distances between houses are measured in field lengths, and the nearest neighbour is far enough away that sound does not carry between properties. She also wrote a note. The note was handwritten, detailed, and constructed entirely to be found after the fact by whoever came looking. It described a man who had forced the family at gunpoint from their car at a gas station stop and made them drive to the area near the pond. It said Michelle had tried to fight him off with pepper spray and that he had knocked her unconscious. At the bottom of the note, in a detail that prosecutors read aloud in their opening argument, Michelle had written, "Oh no, here he comes again." Prosecutors told the jury she had written the note not after the attack, but during it, while her sons were present, as deliberate stage setting for whoever discovered the scene. On the drive that Sunday, Michelle stopped at a convenience store in Jessup and asked the clerk where the nearest playground was. Prosecutors argued this was a calculated stop designed to allow her to leave her phone behind, creating a gap in the digital record that would make it harder for investigators to place her at a specific location. She drove to the pond. She parked the van near the water's edge. She took Sean out of the vehicle first. She placed duct tape over his eyes, his nose, and his mouth. She removed the knife. She cut his throat and put him back in the van. Then she went to Seth. She cut his throat twice. He was 2 years old, and he died at the edge of the water beside the van. Michelle then walked to the pond and turned the knife on herself, cutting her own throat in what prosecutors described as a suicide attempt that failed because the wound was not deep enough to be fatal. When it became clear she was not going to die from it, she wrapped her throat as best she could and staggered approximately half a mile down the county road to the nearest house. That was Deborah Hinney's house. That was where the piece of paper came out and the 4 words went down. When Sean gave his account to investigators, it was recorded on audio tape the morning of October 27th, the day he was found. He was 7 years old. He spoke in a high, thin voice that carried in the courtroom when prosecutors played the recording at trial, in a way that produced the kind of silence that replaces every other sound in a room. He described how his mother placed the tape over his face, over his eyes and nose and mouth. He said she cut him. He said she was hurting his baby brother. He described how, after she left him in the van and walked toward the water, he had worked the tape loose from his face and locked the van doors from the inside and stayed there through the night without knowing what was outside the door. He had been in that van, alone, in the dark, for approximately 15 hours before emergency responders found him the following morning. He did not know Seth was dead a few feet away on the ground outside. The audio recording was played in its entirety for the jury. Every juror who spoke to press afterward said it was the moment that settled everything for them before deliberations had even begun. Michelle's defense rested entirely on the insanity argument. Her public defenders, Andrea Dreyer and David Stout, called a psychologist named Dr. Marilyn Hutchinson, who testified that Michelle suffered from severe depression, anxiety, and a constellation of psychiatric conditions that had placed her, in Hutchinson's professional assessment, at high risk for psychotic thought at the time of the attack. The defense positioned what happened at the pond as an act committed by a woman who genuinely believed she was saving her sons from a life of suffering she felt was inevitable, and who had lost the legal capacity to understand that what she was doing was wrong. Hutchinson described her as a tortured soul. The prosecution called its own expert, Dr. Michael Taylor, a psychiatrist who told the jury there was no evidence that Michelle's mental state had crossed the legal threshold for insanity. Assistant Attorney General Andrew Prosser laid the argument out plainly for the jury in closing. He asked them to consider the knife purchased a month in advance, the duct tape, the deliberate stop to lose the phone, the handwritten note constructed to point blame at a stranger, the story delivered on Deborah Hinn's doorstep. He asked, if she did not know her actions were wrong, why had she spent weeks preparing a story to tell the world that someone else had done it? The jury deliberated for less than 2 hours. On November 5, 2009, they returned guilty verdicts on all 3 charges: first-degree murder for Seth, attempted murder for Sean, and child endangerment causing serious injury. Under Iowa law, first-degree murder carries a mandatory sentence of life without the possibility of parole. At sentencing in December 2009 at the Buchanan County District Courthouse in Independence, Buchanan County Attorney Alan Vanderhart asked the judge to run the murder sentence and the attempted murder sentence consecutively, citing the fact that there were 2 separate victims and that the planning and premeditation involved in the attack warranted the maximum available accountability. The judge agreed. Michelle Kehoe received life without parole for Seth, a consecutive 25 years for the attempt on Sean, and the concurrent 10 years for the child endangerment charge related to Sean's injuries. Gene Kehoe stood at the sentencing and read a statement. He said the events of that year had brought such great sadness that the word barely covered what his family was carrying. He said he still loved his wife. He described her as the mother she had been before whatever had broken, and he asked the court to consider her with understanding and compassion. He wept during parts of it and stopped several times before finishing. Michelle sat beside her attorneys and heard every word. She did not address the court. In a later interview granted while her new trial motion was being considered, she said she had needed the jury to hear her experience, to understand that what had happened had felt beyond the control of a healthy mind, that her intentions had never been what her hands produced. She said she had not taken the stand at trial because she had not felt stable enough to do it. Sean Kehoe was 20 years old when that interview was published. He was raised by extended family after his mother's arrest. He does not speak to her. Michelle Kehoe is serving her sentence at the Iowa Correctional Institution for Women in Mitchellville, where she has been since her conviction. The Hook and Liner Pond sits where it has always sat outside Littleton, at the end of a county road in Buchanan County, surrounded by fields that go gold in October and bare through winter and green again every spring. A columnist for the Gazette who visited the pond in the weeks after Seth's death wrote that the fallen leaves near the shoreline looked like tiny, shriveled hands covering the tire tracks in the mud. The investigators had packed up and gone. The barricades were down. All that remained, she wrote, was what had been there before. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case crosses to Auckland, New Zealand, where 2 children's remains sat sealed inside suitcases in a storage locker for 4 years, before a family who bought the unit's contents at auction pried them open and found what was inside. Case 5. Hak-Young Lee. On a morning in August 2022, a family in the Clendon Park area of South Auckland brought home a trailer load of items they had purchased at an online auction for an abandoned storage unit near the suburb of Papatoetoe. Storage unit auctions are commonplace in New Zealand, as they are elsewhere, a practical mechanism for clearing out lockers whose rental fees have gone unpaid long enough that the facility is entitled to recover the space and recoup costs. The family sorted through what they had bought: household goods, furniture, ordinary objects accumulated by whoever had rented the unit before they did. Among the items were 2 suitcases, peach-coloured, sealed. When the family noticed an unusual smell coming from one of them and opened it, they found human remains inside. They called the police. The second suitcase contained the remains of another child. The children were wrapped in plastic. They had been in those cases, in that locker, in that facility on the outskirts of Auckland, for approximately 4 years. Their names were Minu Joe and Yuna Joe. Minu had been 6 years old when he died. Yuna had been 8. The family that had rented that storage unit, and whose name appeared in the facility's records, was not in New Zealand. The woman police were looking for had left the country in the weeks following the deaths in 2018. She had travelled to South Korea, the country where she had been born, and she had changed her name. The name she had used in New Zealand was Hakyung Lee. The name she went by in South Korea was Ji-yoon Lee. 4 years passed between the deaths and the discovery. 4 more months passed between the discovery and her arrest. She was taken into custody in the port city of Ulsan in South Korea in September 2022. She was extradited to New Zealand in November of that year and appeared at the Manukau District Court in South Auckland, where she entered no plea. It would be nearly 3 more years before the case came to trial. Hakyung Lee had been born in South Korea in 1979 and migrated with her family to New Zealand in 1993 when she was 13 years old. She returned to South Korea at 18 for her university education, then came back to New Zealand and studied hospitality. At a church in Auckland, she met a man named Ian Jo. She also served as a Sunday school teacher at the same church. Ian and Hakyung married in 2006. They moved from an apartment to a house, first in West Auckland, then in Papatoetoe, a suburb in the city's south. Ian worked as a supervisor at Auckland Airport. Hakyung became what New Zealand describes as a homestay mother, managing the household and the children's lives full-time. Yuna arrived in September 2009. Minu followed in March 2012, born with a cleft palate that gave him a speech impediment he was working through with support at school. The family attended church. The children were enrolled at Papatoetoe South School. Their teacher, Mary Robertson, gave evidence at trial about the children she had known. She described Yuna as beautifully behaved, and Minu as a joyful, bubbling boy. Robertson said the last time she saw Hakyung Lee was when Lee came to the school to inform her of Ian Jo's death in late 2017. Lee told Robertson she had plans to return to Korea after a trip to Australia, where the family would be supported by relatives. It was the last conversation they had. At the start of 2018, when school resumed after the summer break, Yuna and Minu did not appear. The school made contact attempts. Phone calls went unanswered. Staff made home visits and found nothing that resolved the question of where the family had gone. After 20 days of unexplained absence, the school followed the Ministry of Education's established reporting process. The ministry conducted its own inquiries, but did not report the outcome back to the school, as its process did not require it to do so. Minu and Yuna Jo fell out of every system that might have found them. Nobody reported them missing to police. Nobody filed anything that would have triggered a welfare check with consequences. They simply ceased to appear, and the machinery that existed to notice that kind of absence did not produce an alarm loud enough to matter. Ian Jo had been diagnosed with cancer and died in November 2017, 7 months before the children's deaths. He was the financial provider, the structural anchor of the household, and by all accounts from family members who gave statements at sentencing, a devoted father whose illness and death had devastated the family. What that loss did to Hakyung Lee was documented at trial through the accounts of those around her and through her own admissions. A palliative care counsellor who had worked with Ian during his illness told the court that Hakyung had said during that period that she wanted it all to be over, and that she had mentioned on multiple occasions the idea of ending both her life and Ian's. After Ian died, those thoughts did not resolve. They deepened and shifted. At some point she arrived at the belief, or something she described as a belief, that the only answer was to take the children with her when she went. In June 2018, several months after Ian's death, Hakyung Lee laced her children's fruit juice with doses of a prescription antidepressant medication called nortriptyline. A toxicology examination of the remains, conducted years later after the discovery, concluded that the children had died by homicide of unspecified means associated with an antidepressant drug. The defence conceded at trial that Lee had killed the children in this way. What the defence contested was whether she had known what she was doing was morally wrong. Lee said she had intended to take the same medication herself and die alongside them. She said she got the dose wrong. She said when she woke up, they were dead and she was not. The prosecution's response to that account was pointed and direct. Crown Solicitor Natalie Walker told the jury that Lee's behaviour in the days immediately following the children's deaths did not resemble the behaviour of a woman in the grip of uncontrollable grief who had survived a suicide attempt. In the days after Minu and Yuna died, Hak-young Lee purchased a business-class airline ticket to South Korea. She spent approximately $900 at a hair salon. She bought a lotto ticket. She wrapped her children's bodies in plastic bags, placed them inside the peach-coloured suitcases, transported those suitcases to the Safe Store facility in Papatoito, paid for a rental unit, and placed the cases inside. She locked the unit. She flew to South Korea. She changed her name. She began building a life under the name Ji-eun Lee in a country where no one who encountered her would have known she had left 2 children sealed in luggage in a storage facility on the other side of the world. Walker told the jury in her closing argument that what Lee had done was a selfish act to free herself from the burden of parenting alone. She said the evidence of planning, the purchase of the ticket, the salon visit, the calculated concealment of the bodies, the name change, the departure, all pointed to a woman who understood exactly what she had done and who immediately took steps to ensure she would not be held responsible for it. The defence maintained throughout that the jury should look at the totality of Lee's mental state, that her fragility was real, that her descent after Ian's death was genuine, and that a woman in that condition could not be held to the same standard of criminal responsibility as someone acting with full understanding of the wrongfulness of her actions. New Zealand's legal standard for an insanity defence requires a defendant to prove they were incapable of understanding what they were doing or knowing that it was wrong. The jury deliberated for 2 hours after a 2-week trial. On September 23, 2025, they returned guilty verdicts on both murder charges. The defence of insanity was rejected. The sentencing hearing took place on November 26, 2025, at the High Court in Auckland before Justice Geoffrey Venning. Family members who had lost Yuna and Minu submitted statements that were read into the record. The children's uncle, Jimmy Se-wook-jo, said he had never imagined such a profound tragedy could befall his family. He said he felt he had failed to look after his niece and nephew. Lee's own mother, Choon-ja Lee, submitted a statement that was read by a prosecutor. She said it had felt like a pain that cut through her bones, like someone was gouging out her chest. She said she did not know when the pain and suffering might heal, and that she thought she might carry it until she died. She said the acts her daughter had committed were horrific, cruel, and terrifying, and that there was no dispute about that. Then she asked the question that no legal proceeding could answer. If she wanted to die, Choon-ja Lee wrote, why did she not die alone? Why did she take the innocent children with her? Lee's brother-in-law, Se-wook-cho, submitted a statement that carried a detail that stood apart from everything else in the sentencing record. He said the children's other grandmother, Ian-jo's mother, was ill with cancer and still did not know about the murders. He said his daily existence had become what he described as a time bomb of fear that she would find out. He said it had been his late brother's wish that he protect the children and that he carried the weight of having been unable to do so. He said they had been the family's hope for the future. Justice Venning sentenced Hak-young Lee to life imprisonment with a minimum non-parole period of 17 years. He told her directly that while she had undoubtedly been experiencing severe depression at the time of the killings, her actions had been deliberate and calculated. He said, "You could not cope when your husband became seriously unwell, and perhaps you could not bear to have the children around you as a constant reminder of your former happy life, which had been cruelly taken from you." Under New Zealand's compulsory mental health treatment law, he ordered that she begin her sentence at a secure psychiatric facility, with a requirement that she return to prison once assessed as mentally fit. New Zealand abolished the death penalty in 1989. Life imprisonment is the harshest sentence available under its law. The 17-year minimum means Lee will be eligible to apply for parole in her early 60s at the earliest. After the sentencing, Detective Inspector Tofilau Farmanui Va'ailua issued a statement on behalf of the Auckland Police, who had worked the case from the 2022 discovery through the extradition and trial. He said Yuna and Minu would have been 16 and 13 years old on the day he was writing. He said the investigation's thoughts were with the wider family for the tragic loss of those 2 young children. At Papatoetoe South School, the principal said her thoughts were very much with all those who had known and loved Una and Minu. A child protection advocate who spoke to Radio New Zealand after the sentencing said the education and health systems that had allowed 2 children to vanish from their records without triggering a police welfare referral needed to be examined, and that the ministry processes in place at the time had not been fit for the purpose of protecting children in situations like theirs. Minu Joe was born in March 2012 with a cleft palate and a speech delay his teachers were helping him work through. His teacher called him a joyful, bubbling boy. Una Joe was born in September 2009 and sat in her classroom at Papatoetoe South School, being described by her teacher as beautifully behaved. In the summer of 2018, they stopped coming to school, and 4 years passed before anyone found them. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case returns to the United States and to Orlando, Florida, where a 2-year-old girl named Kaylee Anthony was last seen alive on June 16, 2008, and where her mother spent the 31 days that followed telling everyone around her a series of stories that grew more elaborate and less coherent with every telling. Case 6. Casey Anthony. Kaylee Marie Anthony was born on August 9, 2005, in Orlando, Florida, to a 20-year-old mother who had spent several months of the pregnancy denying it was happening. She grew up in a 4-bedroom house on Hope Spring Drive in East Orlando, a house that belonged to her grandparents, George and Cindy Anthony, in a neighborhood of modest yards and lined driveways, where children rode bikes in the late afternoon. George had worked in law enforcement, Cindy was a nurse. The household was busy and at times contentious, shaped by decades of family dynamics that would surface in courtrooms years later in ways nobody in the neighborhood on Hope Spring Drive could have predicted in 2005, when Kaylee was small enough to carry on one hip and new enough to the world that everything in it still surprised her. By all accounts from those who knew her in those early years, Kaylee was vivid and present and easy to love. She was approaching her 3rd birthday in the summer of 2008, old enough to have preferences and opinions and a personality that her grandparents described in interviews as sparkling. Cindy Anthony spoke about her granddaughter the way people speak about someone who had been the light of a room, the one whose arrival changed the temperature. George Anthony testified at trial that he watched his granddaughter leave with Casey on the morning of June 16, 2008, that he saw her in the driveway, that he waved goodbye. It was the last confirmed sighting of Kaylee Marie Anthony alive. Casey Anthony was 22 years old in June 2008 and had been living in her parents' house with Kaylee since the child's birth. She told people she worked at Universal Studios in Orlando, a claim she had maintained for years across different social circles. She did not work at Universal Studios. She had not worked there for years. She told Kaylee's grandparents varying stories about who the child's father was, at different points naming men who had died in car accidents, a construction that made the claims impossible to verify. She stole money from her mother, from her grandmother, from friends, writing checks and using cards that weren't hers, accumulating a pattern of deception that people who knew her described as having been present since high school, a habitual reaching for whatever story the moment required. Her former fiancé Jesse Grund, who had loved Kaylee and described her as an amazing little baby, told investigators and later the court that the Casey he knew when they were together was not someone he could have imagined capable of harming her daughter. He also said the Casey he saw during the investigation was someone he no longer recognized at all. The last day Kaylee was seen alive followed a Father's Day argument at the Hope Spring Drive house on June 15th. The specifics of what was said during that argument were disputed at trial, but what is established through George Anthony's testimony and other evidence is that Casey left with Kaylee the following morning, June 16th, and did not return. George testified he watched them go. 31 days passed. During those 31 days, Casey was photographed at bars and clubs around Orlando. She attended a party at Lake Eola for the 4th of July fireworks. She participated in a hard body contest at a nightclub called Fusion. She got a tattoo on her left shoulder that read, in Italian, Bella Vita, beautiful life. She told her mother, in the sporadic phone contact she maintained, that everything was fine, that Kaylee was with the babysitter, that they were in Tampa on a work trip, that there was nothing to worry about. She told different versions of those stories to different people across different days, and none of them pointed in the same direction. On July 15th, Cindy Anthony reached a point where the accumulating inconsistencies in Casey's account forced her hand. She had located Casey through a friend named Amy Heisenga, who confirmed that Casey was not in Tampa or Jacksonville as she had claimed, but was staying at her boyfriend Tony Lazzaro's apartment in Orlando. Cindy drove to the apartment and confronted her daughter. She demanded to see Kaylee. Casey got in the car without explaining where they were going, driving Cindy around Orlando in a direction that resolved nothing. Cindy called police from the car in a state of escalating alarm. She called 3 times in total that evening. In one of those calls, she told the dispatcher that the car Casey had been driving smelled like a dead body had been inside it. She told the dispatcher her granddaughter had been missing for a month. When officers arrived at Lazzaro's apartment, Casey told them her daughter had been taken by her babysitter. She identified the babysitter as Zenaida Fernandez Gonzalez. She said she had last left Kaylee at an apartment in the Sawgrass complex. She said she had been conducting her own investigation into the babysitter's whereabouts for the past month, and had not contacted police because she was trying to handle it herself. The apartment at Sawgrass had been vacant since February 2008, more than 4 months before Casey claimed to have left her daughter there. A real woman named Zenaida Fernandez Gonzalez existed and was located by investigators. She had never met Casey Anthony or Kaylee. She had never babysat anyone in the Anthony family. She would later sue Casey for defamation. Casey was arrested on July 16, 2008, on charges of child neglect, giving false statements, and obstruction of a criminal investigation. She was released on bond and continued, in interviews with investigators and in meetings with her defense attorneys, to maintain that the babysitter had taken Kaylee and that she had been trying to find her. On July 17th, a cadaver detection dog named Jerris was deployed to examine Casey's car, a white Pontiac Sunfire that had been abandoned in an impound lot and retrieved by George. The dog alerted in the trunk. His handler testified later that the dog had lain down in the trunk, which was the signal trained into him to indicate the presence of human decomposition. Forensic testing of air samples from the trunk later produced evidence consistent with human remains having been present. A stain in the trunk lining was also identified. Casey's defense would challenge the reliability of that evidence at trial. The trunk itself, the smell George and the tow yard manager had both independently registered when they first retrieved the car, was something neither of them ever stopped describing in the same terms. Investigators took Casey on a tour on July 16th to retrace the steps she claimed to have taken in searching for Kaylee. She led them to Universal Studios, where she told them she had an office. Security walked her through the park to the offices she claimed. She walked down a hallway and then stopped. She turned to the investigators and told them she had not worked at Universal Studios for over 2 years. The claim had simply evaporated, replaced by nothing in particular. Kaylee was formally reported as a missing child. A massive ground and air search was organised across the Orlando area. Volunteers assembled, tip lines were established, the national media arrived and stayed. Casey Anthony remained in the custody of the Orange County Jail from October 2008, when the murder charge was filed, through the verdict in July 2011, nearly 3 years. On December 11, 2008, a utility worker named Roy Kronk was walking a wooded area less than half a mile from the Anthony house on Hope Spring Drive when he found skeletal remains inside a laundry bag, wrapped in a blanket, lying on the ground. Investigators later learned that Kronk had actually attempted to direct police to that same general area months earlier, in August, and had been told to call back, a detail that would become a thread the defence pulled at trial. The remains were confirmed as Kaylee Anthony's on December 19, 2008. The Orange County Chief Medical Examiner, Dr. Jan Garavaglia, conducted the examination and ruled the manner of death a homicide of undetermined means. The skull was found with duct tape around the nose, mouth, and jaw area. The state of decomposition after 6 months made it impossible to establish a precise cause, or date of death beyond the established window of June 2008. The trial began on May 24, 2011, at the Orange County Courthouse in Orlando, with Judge Belvin Perry presiding. Jury selection had taken place in Clearwater to avoid the saturation of pre-trial publicity in the Orlando area. The prosecution, led by Linda Drain Burdick and Jeff Ashton, told the jury that Casey had used chloroform to render Kaylee unconscious, applied duct tape over her nose and mouth, and left her body in the trunk of the Sunfire before eventually disposing of her in the wooded area near the house. They presented evidence of chloroform-related searches on the Anthony family computer, though the number of searches was disputed after a software error was discovered and the figure revised sharply downward. They presented the cadaver dog testimony, the forensic air sample analysis, the trunk stain evidence, and the 31 days of documented behaviour. They presented photographs of Casey at clubs and parties taken during the period Kaylee was missing. They presented the Bella Vita tattoo. Ashton told the jury in closing that something had needed to be sacrificed and that Casey had chosen her child. The defence, led by Jose Baez, opened with a claim that stunned the courtroom and set the tone for 6 weeks of proceedings. Baez told the jury that Kaylee had not been murdered. He said she had drowned accidentally in the Anthony family's backyard swimming pool on June 16, 2008, and that George Anthony had discovered the body, and that the subsequent 31 days of lies and misdirection were Casey's response to a family that had long required her to keep secrets. He alleged that George Anthony had sexually abused Casey from the age of 8, creating in her a deeply conditioned reflex to conceal distressing information rather than report it. George denied both the abuse and any involvement in concealing Kaylee's death. The defence did not call Casey to testify. The jury deliberated for 10 hours and 40 minutes. On July 5, 2011, they returned not guilty verdicts on the charges of first-degree murder, aggravated child abuse, and aggravated manslaughter of a child. They found Casey guilty on 4 counts of providing false information to law enforcement. The verdict produced a wave of public response that commentators described as unlike anything seen since the O.J. Simpson case, with hundreds of thousands of social media posts in the hours immediately following the announcement, and crowds gathered outside the courthouse who required police management. Time magazine would call it the social media trial of the century. Judge Belvin Perry sentenced Casey to 4 years on the lying counts, 1 year per count to run consecutively, plus fines. Because she had been incarcerated since October 2008, she had accumulated more than 1,000 days of time-served credit. She was released from custody on July 17, 2011, 10 days after the verdict. She was also ordered to pay $217,000 to the state of Florida to cover investigative costs incurred from the time Kaylee was reported missing through the opening of the homicide investigation. The Florida Department of Children and Families completed a 3-year investigation into Kaylee's disappearance and death, and released its findings in August 2011. The agency concluded that Casey Anthony had failed to protect her child from harm either through her actions or her lack of actions, and that this failure had resulted in the child's death. The identity of Kaylee's father was never publicly established. In 2017, Casey gave a brief interview to the Associated Press and said she understood the reasons people felt about her the way they did. She said she could not tell anyone one way or another what had happened, and that the last time she saw her daughter, she believed Kaylee was alive and was going to be okay, and that was what she had been told. She did not say who had told her that. In 2025, she posted a video to TikTok announcing herself as a legal advocate, saying she intended to advocate for herself and for her daughter. Kaylee Anthony would have turned 20 years old in August 2025. She is buried at the Anthony's family plot. The wooded area near Hope Spring Drive where her remains were found was cleaned and cleared after the investigation concluded. People left flowers there for a long time afterward. Eventually, they stopped. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case moves to a catering hall in Aberdeen Township, New Jersey, on the night of June 6, 1997, where an 18-year-old named Melissa Drexler walked into a restroom at her senior prom and emerged 20 minutes later without the child she had been carrying for 9 months, a child no one outside her own body had known existed. Case 7. Melissa Drexler. The Garden Manor Catering Hall in Aberdeen Township, New Jersey, sits in the kind of suburban landscape that accumulates across the northeast without announcing itself. A low building behind a parking lot on a commercial stretch of road where the surrounding area is half residential and half commercial, and where nothing about the exterior would suggest the interior had ever been a room full of teenagers in formal wear, stepping carefully around each other with corsages and rented shoes. On the evening of June 6, 1997, it was exactly that. Lacey Township High School was holding its senior prom. 300 young people, most of them 18 years old, had gathered for the occasion, in clothes they had spent weeks selecting, with dates they had spent weeks arranging, with photographs taken in someone's living room beforehand, and a night that would become the last notable event of high school before the summer arrived, and then September, and then everything that came after. Melissa Drexler arrived with her boyfriend John Lewis at approximately 7:30 in the evening. She had been experiencing what she described as stomach cramps during the drive from Forked River, the section of Lacey Township where she lived with her parents. When the car pulled into the parking lot and she got out, she walked straight to the women's restroom. Melissa Drexler had been born in 1978, the only child of a middle-class Catholic family in New Jersey. Her father worked as a shipping clerk for an importing company. Her mother worked at a local bank. The household was stable and unremarkable in the way that most households are unremarkable from the outside. A family that attended church, that kept its routines, that produced one child who was described by those who knew her as quiet and self-contained and focused on the future she had mapped for herself. Melissa was 5 feet 7 inches tall and weighed approximately 130 pounds and was, by every account from classmates and teachers and people who saw her regularly through the months of 1996 and 1997, visibly not pregnant. She had a gift for drawing. She wanted to work in fashion. She had enrolled at Brookdale Community College for the fall, planning a course of study in design. She had a summer job lined up at a retail store near the beach. She had been dating John Lewis, who was 2 years older than her and already out of high school, since they were introduced through a mutual family acquaintance. She had been pregnant since late 1996, roughly 9 months, and she had told no one. Not John Lewis, not her parents, not her friends, not the counsellors or medical professionals who might have directed her toward options that did not end with a body in a trash can in a catering hall bathroom. The Monmouth County prosecutor who later reviewed the case told reporters that Drexler had felt her pregnancy was a serious problem, something she was ashamed of and wanted to hide, and that she had responded to that shame by constructing a wall of denial so complete that it held through morning sickness and physical growth and the full 9 months of a pregnancy carried to term in a body that, by every account from the people who saw her every day, showed nothing that prompted a question. Her defense attorney, Stephen Secker, would later tell the court that Drexler had a developmental and learning disability that compounded her capacity to process and address the situation, and that she had not been in denial about the pregnancy itself, but rather about how to handle it. She knew she was pregnant. She had known for months. What she had refused to do, in every direction available to her, was act on that knowledge in any way that would require telling another person what was happening inside her body. Her water broke the morning of June 6, 1997, prom day. She had been awake and aware of it, and had dressed and gotten into John Lewis's car and travelled to Forked River, where photographs were taken in someone's home, and then to the Garden Manor, where the parking lot was filling up and people were taking more photographs, and the decorations inside had been arranged by volunteers from the class for weeks. When she arrived and walked to the restroom, she was in labour. A friend followed her in. From inside the stall, Melissa told her friend she would be out in a few minutes, and to go tell the boys they would be right out. The friend left. What happened inside that stall in the next 20 to 30 minutes was reconstructed through Drexler's own account, given at her plea hearing in August 1998, and through the physical evidence recovered from the scene and from the autopsy. She gave birth into the toilet bowl. The baby was a boy. He was full term, 6 pounds and 6 ounces, and the medical examination that followed his discovery would determine that he had been born alive. His lungs had air in them. His intestines had air in them. These were the findings that established live birth to the legal standard required. Drexler told the court at her plea hearing that she had taken the baby from the toilet, that she had knowingly wrapped him in a series of garbage bags, that she had placed him in a second garbage bag and knotted it closed and put it in the trash can in the bathroom stall. She told the court she was aware of what she was doing when she did it, and aware that what she was doing would most certainly result in the death of the baby. The medical examiner's findings indicated marks around the child's neck, consistent with strangulation, though Drexler's account at plea hearing did not specifically address that finding in detail. She used the serrated edge of the sanitary napkin dispenser mounted to the stall wall to sever the umbilical cord. She fixed her clothing. She left the restroom. She walked back to the prom floor. What she did next was documented by every person who was there that night and who later spoke to investigators or the press. A collective account so consistent in its details that it produced a particular kind of national stunned silence when it emerged. She danced. She ate a salad. She sat with her friends and her boyfriend at their assigned table and moved through the prom the way everyone else in the room was moving through it, as though the previous half hour had been unremarkable and the evening was exactly what it was advertised to be. Someone reported blood on the bathroom floor to a school staff member. A maintenance worker was dispatched to clean the restroom. While carrying the trash bag from the bathroom out of the building, the worker noticed the bag felt too heavy. He looked inside. The baby was found at approximately 8:15 in the evening, less than an hour after the prom had begun. Emergency services were called. An ambulance arrived. The medical team worked to save the infant for 2 hours. He was dead. While this was happening in the parking lot and then in the emergency vehicles outside, Melissa Drexler was still inside the Garden Manor attending her senior prom. She was asked by a teacher or staff member, along with others who had been near the restroom, whether they knew anything about the blood in the bathroom. She said she had been having a heavy menstrual period. She was 18 years old, and she stood in a prom venue with her boyfriend and her friends and gave that answer to an adult who was asking about blood on the floor, while her child was being worked on by paramedics in the parking lot outside. She was not arrested that night. She was arrested on June 24, 1997, 18 days after the prom, after the investigation had established the physical evidence, confirmed the autopsy findings, and obtained sufficient basis for a murder charge. A Monmouth County grand jury indicted her on September 17th. She was arraigned on October 27th. The initial charge was first-degree murder. The case attracted the kind of national attention that certain cases pull when a detail inside them is so contrary to expectation that the public cannot stop turning it over. A senior prom, a full-term baby, a salad, a dance. The details arrived in newspapers and on television in the summer of 1997 and became a cultural reference point for discussions about teenage pregnancy, denial, shame, and the failures of every system that might have intervened before June 6th and did not. Melissa Drexler did not speak publicly about the case between her arrest and her plea hearing. Psychiatric reports submitted by her defense attorneys described a young woman who had been in a state of sustained psychological denial, not about the existence of the pregnancy, but about the necessity of addressing it, a distinction that the prosecution and much of the public found difficult to accept as meaningful. The prosecutor, Monmouth County Prosecutor John Kay, told reporters at the time of the plea that Drexler had never expressed remorse for what she had done to the child, though her defense attorney argued that her flat courtroom presentation was the product of nerves rather than indifference. Her parents sat through the plea hearing in silence. Her mother and father listened to their daughter describe, in what CBS News reported as emotionless words delivered in a childlike voice, the specific sequence of what she had done in that bathroom stall, and neither of them had known until after the arrest that their daughter had been pregnant. The plea agreement reduced the charge from first-degree murder to aggravated manslaughter. She appeared for sentencing on October 29, 1998, at the Monmouth County Superior Court in Freehold before Judge John A. Ricciardi. She was 20 years old. She wore a bulky grey sweater. She wept through much of the hearing. When Judge Ricciardi asked if she had anything to say, she spoke one sentence. She said she would like to tell the court she was really, truly sorry for what she had done. The judge sentenced her to 15 years in prison, with eligibility for parole after 3 years. He described the case as very difficult, made more so by the intensity of the media interest surrounding it. He said her actions were explainable, but not excusable. He said the law was concerned that a very precious and helpless life had been taken, and that the taking of every life demanded accountability, and that forgiveness should never displace responsibility, and compassion should not displace accountability. He said she was not a monster. He said she was not someone to be gawked at or vilified by the public or the press. He said she was entitled to understanding and compassion and prayers. Outside the courthouse, her defense attorney said the circumstances of the case would obviously never occur again, and that his client had a disability that contributed to her inability to cope with what was happening. He said she knew it was something she would have to live with for the rest of her life. The baby was named Christopher by his maternal grandparents, the same two people who had sat silent in the courtroom while his mother described disposing of him in a trash bag. He was buried privately. A birth certificate was issued. A death certificate was issued. He was 6 pounds and 6 ounces, and he had been alive. Drexler served 37 months at the Edna Mahan Correctional Facility in Clinton, New Jersey, the state's only maximum security prison for women. She was released on parole on November 26, 2001, at the age of 23. She had earned her high school diploma while incarcerated, having graduated in absentia from Lacey Township High School in 1997, but not attended the ceremony. She had taken fashion courses in prison, pursuing the same interest she had carried into that summer before everything changed. She did not attend her high school graduation. She was released, and by all subsequent accounts, disappeared into a private life from which she has not emerged in any documented public capacity since. John Lewis, her boyfriend on the night of the prom, broke up with her following the arrest. They have not spoken publicly since. The New Jersey legislature had a specific relationship to the timing of this case. 3 days after the prom, on June 9, 1997, the No Early Release Act took effect in New Jersey, a law requiring that individuals convicted of certain violent offences serve at least 85% of their sentence before becoming eligible for parole. Had the act been in force on June 6th, Melissa Drexler's 15-year sentence would have required her to serve at least 12 years and 9 months before her first parole hearing, rather than 3. She was sentenced under the law as it existed on the night of the prom, 3 days before that threshold passed. Her parole attorney noted this to the press at the time of her release. The prosecutor's office said they opposed early parole on general principle, but acknowledged the likelihood of her constituting a threat to the public was minimal. The case became a framework around which psychiatrists, child welfare advocates and legal scholars examined the phenomenon of pregnancy denial, a condition documented in medical literature in which a woman who is pregnant either does not consciously register the pregnancy or processes that knowledge in a way that produces no behavioural response aligned with what is happening in her body. Researchers examining the Drexler case noted that denial of this depth and duration typically involves a combination of psychological factors, including profound shame, fear of social consequences, and in some cases a dissociative response to a situation the mind has categorised as impossible to survive intact. None of that analysis reached the baby in the trash bag, or the 2 hours the medical team spent trying to reverse what had already been decided inside the bathroom stall. His name was Christopher. He was buried in New Jersey. He was 6 pounds and 6 ounces, and he had been alive, and he had air in his lungs, and the night outside was a prom night in early June in New Jersey, and the parking lot was full of cars. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case moves to Chestnut Ridge, New York, where a 5-year-old boy named Garnet Spears spent his entire short life cycling in and out of hospitals for conditions that his mother documented obsessively on social media, conditions that investigators would ultimately establish she was producing herself through his feeding tube. Case 8. Lacey Spears Garnet Paul Thompson Spears was born on December 3, 2008, at Huntsville Hospital in Alabama, weighing 6 pounds and 14 ounces. He was a healthy newborn by every measure that the delivery room could take. His mother, Lacey Spears, was 21 years old. She was from Decatur, a small city in the northern part of the state, and she had grown up in an environment that relatives and later investigators described as unstable, with limited family support and a childhood marked by instability at home. She was close to extended family, she referred to as parental figures, people outside her immediate household who had provided consistency during years when her biological parents had not always been present in the way a child needed. By the time Garnett arrived, she was a single mother. His biological father, Chris Hill, was a garage door installer and a neighbour in Decatur, whom Lacey had briefly dated. He was not involved in Garnett's life. He was not given the opportunity to be. Lacey told people that Garnett's father was a police officer named Blake, who had died in a car accident before the baby was born. She constructed that fiction with enough detail to maintain it across multiple years, multiple states, and multiple circles of friends and acquaintances who had no reason to question what she told them. She told Chris Hill directly that Garnett was not his son and threatened him to stay away from both of them. Hill complied. The child grew up not knowing his father was alive, and his father grew up not knowing his son was dying. Within the first weeks of Garnett's life, the hospitalizations began. Lacey brought him in for severe ear infections, for projectile vomiting, for dehydration that she described as alarming and unexplained. He was hospitalized multiple times in the first 9 weeks alone. When he was approximately 2.5 months old, he was airlifted to the Children's Hospital of Alabama in a state that the attending physician, Dr. Robert Pass, described at trial as severe dehydration so advanced that his tiny body was in shock. A blood draw taken at admission showed significantly elevated sodium levels. The medical team at Children's Hospital of Alabama ordered an MRI, an EEG, a CT scan, a chest X-ray, and a swallowing study. Every test came back normal. No underlying condition was found. Dr. Pass testified at trial that they never did figure out what was causing the elevated sodium levels. The child stabilized. He was discharged. He went home with his mother. By the time Garnett was 9 months old, his physicians had determined that he was not receiving adequate nutrition through normal feeding and recommended the surgical insertion of a gastric tube, a G-tube, a device implanted through the abdominal wall directly into the stomach to allow nutrition to be delivered without passing through the mouth or esophagus. The procedure was performed. From that point forward, Garnett Spears had a feeding tube, and from that point forward, his mother had direct, unmonitored access to everything that entered his body through it. Across the next 4 years, Lacey brought Garnett to approximately 20 different physicians across multiple states, reporting seizures, developmental delays, allergies, gastrointestinal disorders, and a range of other conditions that shifted and evolved, depending on which doctor was seeing him and what that doctor might be persuaded to prescribe or recommend. No physician ever identified a consistent underlying diagnosis. No test ever returned a result that explained the pattern of crises that kept landing Garnett in emergency rooms. According to Lacey's own social media posts, in the first year of his life, he was hospitalized 23 times. Lacey Spears was using every available platform to document her son's medical journey in real time. She posted on Facebook, on MySpace, on Twitter, and on a blog she maintained specifically for that purpose. She referred to Garnett consistently as Garnett the Great. She posted photographs of him in hospital beds, of medical equipment attached to him, of herself sitting beside him with expressions that communicated the weight of a devoted mother carrying an impossible burden. She accumulated an audience across these platforms, people who followed the updates and responded with sympathy and prayers and messages of support. She posted during hospitalizations. She posted in the recovery periods. She posted in the hours before the final crisis and during the final crisis itself, generating 28 posts in the last 11 days of Garnett's life. The final post she made was on January 23, 2014. It read, "Garnett the Great journeyed onward today at 10:20 a.m. She posted that announcement on the same day her son was declared brain dead at the Maria Ferrari Children's Hospital in Valhalla, New York, while investigators were already beginning to piece together what had happened to him and why his sodium level had climbed to a number that the attending physicians described as not compatible with life. In late 2012, Lacey and Garnet had moved from Florida, where they had briefly lived with her maternal grandmother Peggy after leaving Alabama, to Chestnut Ridge, a suburb in Rockland County, New York. They settled in a residential community called the Fellowship, an intentional communal living arrangement that had originally been established for elderly and disabled residents, but that had expanded over time to include younger families and individuals seeking community. The Fellowship had a spirit of collective care that made it exactly the kind of environment in which a young mother presenting herself as devoted and overwhelmed would find sympathy, practical support, and daily witnesses who saw her only as what she showed them. She worked part-time as a daycare provider, caring for other people's young children while managing the ongoing medical narrative surrounding her own. Garnet attended preschool. His teacher later testified that he was a normal, engaged child in the classroom, that he participated, that he was present, that he did not present as a chronically ill child when his mother was not in the room. On January 17, 2014, Lacey brought Garnet to Montefiore Nyack Hospital, telling staff he had been suffering from seizures and headaches. His sodium level on admission was recorded at 138 milliequivalents per litre, which sits within the normal range of 135 to 145. A paediatric neurologist named Dr. Ariel Shabani was called to consult. He examined Garnet on the evening of January 18th and found him awake, alert, and apparently fine. He saw no evidence of seizure activity. An EEG conducted by an epilepsy specialist confirmed no seizure patterns. Shabani testified at trial that he was puzzled by the history Lacey described, particularly her account of Garnet having presented with even higher sodium levels as an infant, during episodes she characterised as similar to the current one. On the morning of January 19th, Garnet's sodium level had risen to a point that required immediate transfer. He was airlifted by medical helicopter to the Maria Ferrari Children's Hospital at Westchester Medical Center in Valhalla. At Maria Ferrari, the sodium reading on admission was 182 milliequivalents per litre. The normal ceiling is 145. A physician on the unit pulled Lacey aside in the hallway and told her directly that it was metabolically impossible for her son's body to produce that level of sodium on its own. He told her something was not right. Despite that conversation, police were not contacted for approximately 2 days. Lacey was permitted to remain in Garnet's room. Surveillance cameras had been installed in the room to monitor for seizure activity, the stated reason for the hospitalisation. Those cameras recorded what they recorded. Footage showed Lacey removing Garnet from his hospital bed twice, taking him into the attached bathroom and returning him to the bed. On each occasion that the footage showed this sequence, Garnet's condition deteriorated sharply in the hours that followed, with his sodium levels spiking to levels that were causing his brain to swell inside his skull. A friend who was present at the hospital during part of the final hospitalisation testified at trial that she did not see Lacey cry once during the days Garnet lay unresponsive in the bed. She said that 5 days before the final collapse, Garnet had been healthy and happy, jumping off the bed and running around the floor at Nyack Hospital. Investigators who searched Lacey's apartment in Chestnut Ridge after Garnet's death found feeding bags that laboratory analysis later confirmed contained approximately 5.5 teaspoons of sodium each, equivalent to 22 adult servings, or 69 individual salt packets of the kind distributed with fast food. The bags were connected to the G-tube that had been surgically inserted into Garnet's stomach when he was 9 months old, and that had remained there for the duration of his life. Forensic toxicologist Christopher Cording testified at trial that the sodium content in those feeding bags was far beyond any nutritional level and was consistent with deliberate administration. The medical examiner who conducted the autopsy, Dr. Alexander Milovanovich, determined the cause of death to be cerebral edema, resulting from acute sodium intoxication. Garnet's brain had swollen to the point where functions ceased. He was declared brain dead on January 23, 2014. He was 5 years old. Lacey Spears moved to Scottsville, Kentucky after Garnet's death. She was living there when, 5 months later, a sealed Westchester County grand jury indictment was unsealed, charging her with second-degree murder and first-degree manslaughter. She surrendered to authorities. She pleaded not guilty. Her defense attorneys argued that she was a devoted mother who had been caring for a genuinely sick child, and that the evidence against her was built on coincidence and assumption rather than proof of intent. They did not introduce a formal psychiatric defense at trial, though the disorder that investigators and medical experts believed was driving her behavior, factitious disorder imposed on another, formerly known as Munchausen syndrome by proxy, was discussed extensively in media coverage surrounding the case. The disorder involves a caregiver, most commonly a mother, who fabricates or actively causes symptoms of illness in a child in order to generate attention, sympathy, and what researchers describe as a particular form of social recognition that the caregiver craves and cannot obtain through other means. Lacey Spears denied having the condition. The trial lasted 14 days in a Westchester County courtroom in White Plains. The surveillance footage from the hospital room was the prosecution's most direct piece of evidence. Prosecutor Doreen Lloyd told the jury in her closing argument that Lacey Spears had used her son's feeding tube as a weapon. She said Garnett should have been in school on the day she addressed the jury. The jury deliberated for 2.5 days before returning a guilty verdict on March 2, 2015. Lacey Spears was convicted of second-degree murder. She showed no emotion when the verdict was read. She did not testify at any point during the trial. Sentencing took place on April 8, 2015, before Westchester County Court Judge Robert Neary. The Westchester County District Attorney's Office, in a statement read at the hearing, described the full arc of Garnett's life. The repeated hospitalizations, the unneeded surgical procedures, the poisoning through the tube that was supposed to feed him, all of it administered by the one person who should have been his ultimate protector. The office said that, although the sentence was lengthy, they would continue to ensure Lacey Spears was held accountable and that justice for Garnett would be served in his memory. Judge Neary acknowledged that Lacey Spears suffered from a mental illness and said that fact had influenced his decision not to impose the maximum sentence of 25 years to life. He sentenced her to 20 years to life and described what she had done as a crime unfathomable in its cruelty. The defense had asked for the minimum of 15 years to life, describing her as a hard-working single mother who had given her son unconditional love. Lacey Spears showed no emotion during the sentencing either. She is currently incarcerated at the Bedford Hills Correctional Facility for Women in Westchester County. Her earliest possible parole date is June 12, 2034. Her conviction was upheld by the New York State Appellate Division, and New York's highest court, the Court of Appeals, declined to review the conviction. Chris Hill, Garnett's biological father, the man Lacey had threatened and lied to and excluded from his son's life, was not permitted to know his son while he was alive. He learned about Garnett through the same channels as everyone else, through the news coverage that surrounded the case after the arrest. Garnett the Great, as his mother had called him on every platform she used to document his suffering, would have been 16 years old in December 2024. He is buried in New York. The feeding bags that had been kept in Lacey's apartment in Chestnut Ridge, the ones that held 5.5 teaspoons of sodium each, are in the evidence record of Westchester County Court. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case moves to Wellesley, Massachusetts, where on a Friday night in April 2026, a woman showed up at her aunt's house in Bennington, Vermont, covered in blood, and told her that she had just killed her 2 children at home and that she had tried to take her own life at a bridge on the way there. Case 9. Jeanette McCausland. Edgemore Avenue in Wellesley, Massachusetts, runs along the western edge of the town near the Natick Line, a quiet residential street in a community that is, by nearly every available measure, exactly the kind of place where nothing like this is supposed to happen. Wellesley sits about 15 miles west of Boston and is home to roughly 30,000 people. The median home value exceeds $1.5 million. Crime rates sit significantly below national averages. The schools are considered among the strongest in the state. Neighbours on Edgemore Avenue describe the street on the Sunday after as hushed, the kind of quiet that is not peaceful but suspended, the kind that settles over a block when something has happened there that no one yet has the language for. Children often played outside in the neighbourhood. Kai McCausland was 7 years old, in 2nd grade at Schofield Elementary. Ella McCausland was 6, in kindergarten at the same school. People who lived near the family told the Boston Globe that they had heard Kai and Ella playing in the backyard most recently, less than a week before their bodies were found inside the house. Jeanette McCausland was 49 years old in April 2026. She had grown up in Vermont, attended college there, and later enrolled at the New England School of Acupuncture in Massachusetts. Her professional biography on the website of New England Integrated Health, the practice where she worked, described her as someone with deep roots in integrative medicine, someone who had spent a year in India during her studies working in a physiotherapy unit at a hospital with children suffering from extrapulmonary tuberculosis, polio, and cerebral palsy. Someone driven by a commitment to healing. She had also worked at Massachusetts General Hospital. After the 2013 Boston Marathon bombing, she had founded a volunteer pop-up clinic called Boston Acupuncture Trauma Relief, which provided free treatment to survivors and first responders in the immediate aftermath of the attack. She was licensed as a massage therapist in Massachusetts. She maintained a social media presence that, by all accounts from people who followed it, showed grinning children, neighborhood life, and the ordinary texture of a family in a well-tended suburb, including at least one post to a community Facebook group asking for cupcake recommendations for an upcoming birthday party. She married Samuel McCausland in February 2016 in Costa Rica. A Boston Globe reference from 1989 identified a Samuel McCausland as a local real estate developer, suggesting a family with established roots in the greater Boston area. Jeanette and Samuel bought their home on Edgemore Avenue in 2018. Property records place the parcel's assessed value at just over $1.2 million in 2026. They had 2 children, Kai, born first, and Ella, born the following year. Both children attended Schofield Elementary. Their babysitter, a young man named Cale Dara, who had worked for the family for approximately a year, told reporters that Kai and Ella were full of life and laughter. He described Jeanette as methodical in her care for the children, careful about planning their meals, attentive to their medications. He told the Boston Globe that he had never entered the house and felt like anything was extremely off. He said he could never have imagined that she would do something like this, that she had seemed to deeply love her children like any other mother he had come across. In October 2025, Samuel McCausland filed for divorce in Norfolk Probate and Family Court. He sought custody of the children and control of the Wellesley home. Jeanette filed a counterclaim the following month, also seeking custody and the home. The proceedings were contentious. The couple's competing claims over Kai and Ella's care and living arrangements became the central axis of the legal dispute that ran through the winter and into the spring of 2026. On April 16th, both parties filed a joint motion agreeing to have a neutral third party appointed to investigate the legal custody and parenting plan issues and make recommendations to the court in the best interests of the children. A guardian ad litem, a psychologist named Dante Spetta, based in Arlington, was appointed effective April 21st. The next court date in the divorce proceedings was scheduled for May 5th. A legal analyst who spoke to NBC Boston after the arrest noted that risk factors associated with domestic legal cases often cluster around high-stress inflection points, and that the recent appointment of the guardian ad litem represented exactly that kind of inflection point, a moment when the shape of the custody outcome was about to become clearer and less controllable for both parties. On the evening of Friday, April 24, 2026, Bennington police in southern Vermont were contacted at approximately 9:15 and asked to check on a woman who had arrived at a family residence in town, appearing highly distraught. The woman was Jeanette McCausland. She had driven approximately 3 hours from Wellesley. Her aunt, whose name appears in the Bennington police affidavit as Mattison, lived in Bennington. Jeanette had arrived by knocking on her aunt's window. Mattison found her hysterical, covered in blood, with a visible gash on her neck. After getting Jeanette to calm down enough to communicate, Mattison checked her neck and observed that the blood on her was dried rather than fresh. She asked about the children. She asked where Jeanette's husband was. Jeanette told her Samuel was at the lake. Then she told her aunt what had happened to Kai and Ella. When Bennington police arrived at Mattison's residence, Jeanette McCausland told them directly what she had done. She said she had strangled the children and left them in her bed at the Wellesley home. She told officers that she had wanted the 3 of them to go to God together, but it did not work. She said she had driven from Wellesley to the Queechy Gorge Bridge in central Vermont, a span over a deep river gorge in the town of Hartford, and that she had tried to jump from the bridge but could not do it. The drive from Wellesley to the Queechy Gorge Bridge and back south to Bennington is estimated to take over 4 hours, meaning Jeanette had spent the hours between the deaths and her arrival at her aunt's house driving through the night, across 2 states, stopping at a bridge and then continuing south. At some point during that drive or before it, she had inflicted the wound on her own neck. When an officer asked about the children after she handed over a holiday family photograph, she shook her head from side to side. She did not deny what she had said she had done. Officers in Bennington contacted Wellesley police and requested a welfare check at the Edgemore Avenue house. The first Wellesley officer arrived at approximately 9:50 in the evening and entered through an unlocked door. He told a dispatcher immediately, "There's blood splatter." Officers located Kai and Ella in a bed inside the house. They were deceased. Their positions in the bed corroborated what Jeanette had told police in Vermont. Massachusetts State Police issued an arrest warrant charging Jeanette McCausland with 2 counts of murder. She was taken into custody in Bennington as a fugitive from justice and held at the Marble Valley Correctional Facility in Rutland, Vermont over the weekend. On Monday, April 27th, she appeared via video conference in Rutland Superior Court, bowing her head to folded hands as she waited for her hearing to begin. Her attorney, Jeff Rubin, told the court that she wished to waive her extradition rights and that she had decided the best thing was to get back to Massachusetts as soon as possible to address the charges. The judge in Vermont approved the extradition. Questions arose about what caused a delay in the actual transfer, as McCausland remained in Vermont custody for days after the waiver before being moved. She appeared in Dedham District Court in Massachusetts on May 6th for her arraignment on the Massachusetts murder charges. She was 49 years old and stood in the courtroom with her gaze lowered and her hands clasped, her left index finger scratching at the back of her right hand in a slow, repetitive motion throughout the brief proceeding. A not guilty plea was entered. She was ordered held without bail. As she was ushered out of the courtroom at the close of the hearing, she appeared to choke back sobs. A small wound was still visible on her neck. Her defense attorney at the arraignment, Joseph Krowski Jr., did not oppose the prosecution's request for no bail, but noted to the judge that he had met his client for the first time approximately 20 minutes before the hearing began, and had not yet been able to have an in-depth conversation with her. He asked that she be held at the Western Massachusetts Regional Women's Correctional Center in Chicopee, rather than a facility closer to Boston, and the judge allowed that request. Jeanette McCausland's divorce attorney, Joanna Staffy, issued a statement saying the firm did not have sufficient information about the circumstances of what had occurred, and that during the period they had known their client, she had been a loving, caring, and deeply devoted mother. Samuel McCausland could not be reached for comment. He had been away when the bodies were found. A Dedham District Court judge granted a prosecution motion to impound the Massachusetts State Police affidavit related to the case for 6 months, citing the risk that its public release would contribute to increased psychological and emotional distress for people involved in the case and cause apprehension among witnesses. The impoundment means that significant investigative detail about what occurred inside the Edgemore Avenue house on the night of April 24th remains sealed as of the date of this recording. A motive, in the legal sense of a formally established account of why the events unfolded as they did, has not been publicly articulated by prosecutors. What is established through police documents and court filings is the custody dispute, the recent appointment of the guardian ad litem, the approaching court date, the drive to Vermont, the bridge, the aunt's window, and the words Jeanette McCausland used when she told the people around her what she had done to her children. Wellesley Superintendent David Lucier addressed the school community in a statement after the children's deaths were confirmed. He said it had been an emotional day for the entire district as they grieved the loss of 2 young students. He said that by all accounts, Kai and Ella were shining lights with close connections to children and adults that extended well beyond Schofield Elementary. He said the district was grateful to the Wellesley community for its outpouring of love for all who had cared for Kai and Ella. Parents of their classmates were left trying to explain to elementary school children why 2 of the children they had sat beside and played with at recess would not be coming back. Neighbours on Edgemore Avenue shared fragments of memory on the Sunday after, subdued and uncertain, trying to account for something that the information available to them could not fully account for. Kai McCausland was 7 years old. Ella McCausland was 6. Jeanette McCausland is due back in Norfolk County Court on July 13, 2026. No trial date has been set. The case is in its early stages, and much of the investigative record remains sealed. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The final case moves to Newcastle County, Delaware, in June 2025, where a 3-year-old girl named Nola Dinkins was reported kidnapped at gunpoint from her mother's car, triggering an FBI-assisted search that ran through the night and into the following day, before investigators determined that no kidnapper had ever existed. Case 10. Darian Randall. Nola Quintrell Dinkins was 3 years old, and the people who knew her described her the way people describe children whose presence fills a room before they have the vocabulary to understand what presence means. Her father, Dominique Dinkins, wrote about her after her death in terms that were simple and direct, and carried the particular weight of a parent trying to put into language something that does not reduce to language. He described her as his one and only child. He said she brought an infectious energy and warmth to everyone she met. A community vigil was organised in northeast Maryland in the days after her remains were found, and people came to honour a child most of them had never met, drawn by the particular grief that attaches to a toddler whose name appeared in an Amber Alert and then in a charging document and then on a donation page for funeral costs, in that order, across the span of 3 days in June 2025. Darian Randall was 31 years old and living in northeast Cecil County, Maryland, with her boyfriend, Cedric Antoine Britton, who was 44. Northeast is a small town of roughly 8,000 people on the upper Chesapeake Bay, positioned at the corner of Maryland where the state presses up against Delaware and Pennsylvania. The area is defined by waterfront proximity and the working-class rhythms of a small county seat, the kind of place where most people know more of their neighbours by face than by name, and where a community vigil in a park draws people who share geography and grief without necessarily sharing history. Randall had a daughter, Nola. She had filed a notice of relocation with Delaware Family Court in January 2025, seeking legal permission to move with Nola. The nature of those proceedings and their relationship to what happened in June were not publicly detailed in available charging documents, but the filing established that custody and co-parenting arrangements around Nola were an active legal matter in the months before her death. On the morning of Monday, June 9, 2025, Darian Randall beat Nola Dinkins with a belt. She struck her approximately 15 to 20 times across her body, according to the confession she subsequently gave to investigators, recorded in charging documents filed in both Delaware and Maryland. The beating occurred at the home on Elk Nest Drive in Northeast that Randall shared with Britton. After the beating, Nola fell to the ground and stopped moving. Randall told investigators that she picked her daughter up and realised she was no longer breathing. She did not call 911. She did not call a doctor. She called for Britton, who was in the house at the time, and who came and attempted CPR on the 3-year-old child. The CPR did not revive her. The child was dead. What followed was documented through Randall's own account to investigators and through charging documents that laid out the sequence of decisions made by both Randall and Britton in the hours after Nola died. Rather than contacting emergency services or law enforcement, the two of them placed Nola's body in Britton's BMW and drove around for a period of time before returning to the Elk Nest Drive house. The drive appears to have resolved nothing except perhaps time, the kind of movement that people sometimes engage in when a decision is being deferred and the body needs to be in motion while the mind works through what comes next. They came back to the house. They placed Nola's body inside a blue suitcase. They left the suitcase on the basement stairs. The night of June 9th passed. Randall told investigators she checked on the suitcase once during the night. The following morning, she asked Britton to take it somewhere. Britton removed the suitcase from the house and transported it to a location he later indicated on a hand-drawn map for investigators. He sent Randall a photograph of a park to show her where he had left it. The suitcase and Nola inside it ended up in a vacant lot on June Drive in Northeast, directly behind Britton's property. Nola's remains were described in court documents as emaciated and completely wrapped in saran wrap. With the child's body disposed of, Randall drove to Newark, Delaware on the evening of Tuesday, June 10, 2025. She was captured on surveillance cameras leaving the Liberty Apartments complex in Newark at 6:59 in the evening without Nola. At approximately 7:15 that evening, she contacted the Newcastle County Police Department and reported that her daughter had been kidnapped at gunpoint. She told officers she had been driving along the 500 block of Gender Road in Newark when she pulled over to comfort Nola, who was upset. She said a man had then approached the car and held her at gunpoint before taking Nola and leaving in a vehicle driven by a second person. She described the man as a white male, approximately 40 years old, bald, with peach fuzz on his head, wearing a black hoodie and grey basketball shorts, carrying a handgun. She described the vehicle's other occupant as a blonde, white woman. The Newcastle County Division of Police and the Criminal Investigations Unit initiated a response. The FBI joined the investigation. An Amber Alert was issued across Delaware and surrounding states. The machinery of a major missing child investigation began turning, directed entirely toward a man and a woman and a vehicle that did not exist. The Newcastle County investigators worked through the night of June 10th and into June 11th. The details of Randall's account accumulated inconsistencies as investigators examined them against the physical evidence available and against surveillance footage from the area around Gender Road. By the morning of June 11th, the direction of the investigation had shifted. Investigators brought Randall in for additional questioning. Under that questioning, the kidnapping story dissolved. Randall admitted the report was false. She then told investigators what had happened on the morning of June 9th. The belt, the 15 to 20 strikes, Nola falling and not moving, the realization that her daughter was not breathing, the call to Britton, the CPR that failed, the drive in the BMW, the suitcase on the basement stairs, the photograph of the park. The full sequence, given back to investigators by the person who had carried it out. Maryland State Police were brought in alongside Newcastle County detectives. On June 11th, investigators interviewed Britton, who during that conversation drew the hand-drawn map of where he believed the suitcase had been taken. Using that map, Maryland State Police located the suitcase in the vacant lot on June Drive in Northeast at approximately 1:45 in the afternoon of June 11th. The remains inside were described in official statements as consistent with those of an emaciated child, completely wrapped in saran wrap. Maryland State Police confirmed on July 11, 2025, that forensic analysis had positively identified the remains as those of Nola Dinkins. The Amber Alert for Nola was formally cancelled after the investigation transitioned from a missing person case to a homicide investigation. The cancellation notice went out to the same phones and screens that had carried the alert 2 days earlier, and the people who had shared the alert and passed Nola's face around the internet absorbed the new information in the particular silence that follows when the worst outcome is confirmed. Darian Randall was charged in Newcastle County, Delaware, with filing a false police report. Maryland State Police charged her with first-degree murder, second-degree murder, first-degree child abuse resulting in the death of a minor under 13, reckless endangerment, neglect of a minor, failure to report a child death, and unauthorized disposal of a body, among other related offences. She was arraigned in Delaware and committed to the Baylor Women's Correctional Institution in Newcastle on $1 million cash bail. She remained there, awaiting extradition to Maryland as of the date available in published records. Cedric Britton was charged in Cecil County, Maryland, with accessory to first and second-degree murder, failure to report a child death, unauthorized disposal of a body, neglect of a minor, and related offences. Despite the Cecil County State's Attorney's objection, a judge released Britton on $75,000 bond, with home detention pending his preliminary hearing. State's Attorney James Delmeyer told reporters that the bail decision had not sat well with his office, and that they had preferred Britton be held without bond. The Cecil County community responded to Nola's death with a vigil held at Northeast Community Park on June 16th, organised by residents and CASA of Cecil County. an organisation that advocates for the best interests of abused and neglected children in the county's courts. Dozens of people gathered. Nola's father, Dominique Dinkins, established a fundraising page to cover funeral costs, memorial service expenses, and attorney fees. In that page, he described his daughter as his one and only child and said she had brought infectious energy and warmth to everyone she met. He had not been present in the home where she died. The charging documents do not indicate his involvement in any aspect of the events of June 9th through June 11th. He was a father who lost a child to the person who was supposed to protect that child from everything the world could do to her. The case carries specific legal complexity because the Amber Alert originated in Delaware, where Randall filed the false report, while the death occurred in Maryland, where Britton's home was located and where the disposal took place. Maryland State Police hold primary jurisdiction over the homicide investigation. Both the Delaware Attorney General's Office and the Maryland State Prosecutor's Office were coordinating the extradition process as of available published records. Both defendants face the possibility of life in prison if convicted on the most serious charges. No trial date had been set as of the most recent information available. Nola Dinkins was 3 years old. The charging documents that described her body described it as emaciated, a word that means something specific in a medical context, something that indicates a child whose physical condition at the time of death reflected conditions that had existed before the morning of June 9th. The charging documents do not elaborate further on that detail, and the investigation as it existed in published records at the time of this writing had not publicly established a full account of the period before the final day. What the documents do establish is what happened on that morning, and what happened in the hours that followed, and the story that was constructed to replace it, and the walk Nola's father took from not knowing to knowing, from an Amber Alert to a charging document to a suitcase in a vacant lot on Dune Drive, behind the property of the man his daughter's mother had been living with. A candlelight vigil was held. People came. They held lights in the dark in a park in northeast Maryland for a 3-year-old girl whose father said she brought infectious energy and warmth to everyone she met. If you enjoyed this breakdown, make sure to subscribe. Thanks for watching, and I'll see you in the next one.